this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on this week's video. On this week's video, we're concluding our 10-part series on the QME Top 10. So today we're actually in session 10. And I just have to say what an amazing series it's been. Now in our very next session, I'll summarize the entire QME Top 10 series for you and give you the salient points and take-home messages from each of the sessions that we've discussed. But for now, I just want to thank you for your participation in this program. Each of the topics of the QME Top 10 program that we addressed were topics that came directly from you, my listeners and my subscribers and customers of Easy QME. So this series, more than any other series we've done, has been, so to say, of the people, for the people, and by the people, or I should say of the doctors and for the doctors. And each session we've addressed specific concerns, specific issues, specific roadblocks, specific barriers, specific concerns that you out in the trenches have expressed to me. And part of the reason that I want to thank you is that in researching these topics for you in order to bring you the solutions to the concerns that you're expressing, I've had to do quite a bit of research myself on most, if not all, of these topics. So it's been a tremendous learning experience for me as well, and I hope you gained a lot of new knowledge from our series as well. And as I said, I'll summarize the entire series for you in about 2 days, 2 to 3 days, as we conclude the program. For today, in part 10 of our series, I want to talk to you about post-termination claims. Post-termination claims. So first of all, what are post-termination claims? Well, post-termination claims are those claims for industrial injury that are filed by the employee or injured worker after a date in time at which they are fired, laid off, terminated, in other words, discharged from their duties of their employment. These are the post-termination claims. Now it's quite interesting because the law, which we'll review in just a couple minutes, tells us exactly how these claims are to be handled. And the law regarding post-termination claims is not the only law that we follow in our QME evaluations of injured workers. And I want to draw a parallel between the law that governs post-termination claims and the law that governs our apportionment determinations. And I want to draw some parallels and explore some similarities between those two laws in order to help define the role of you and I, the QME evaluator, in these particular cases that involve post-termination claims. Now, as far as we're concerned as qualified medical evaluators, it's important that we recognize post-termination claims when we get them. In other words, when you get a request for a QME evaluation, there's a finite number of issues for which we evaluate injured workers. The reasons for which we evaluate injured workers is finite. There's a finite list of reasons. And one of the reasons that we evaluate injured workers is to determine compensability. Compensability examinations are governed under Labor Code 4060. And you'll be able to recognize the compensability claims because compensability claims are those claims that come to us frequently as denied claims. Denied claims. And the job and the role of the QME evaluator in this situation is to determine if the claim should, could, or would be a compensable injury. Well, of all the denied claims that come to us, some of those, a large bulk of those, involve the post-termination claim. Now, the post-termination claim generally comes to us as a denied claim. This is why it's important to recognize what type of an evaluation that we're doing. We only do evaluations under 3 basic labor codes. Labor Code 4060, which is the compensability exam, Labor Code 4061, which is the permanent impairment, the presence and extent of permanent impairment exam, and then Labor Code 4062, which governs all other issues. So we're specifically talking about the examinations that we get under Labor Code 4060, the compensability exam. It's important to recognize what type of exam you're doing before you go into that evaluation, so that you know what your role is, so that you know what your obligation is, so you know what are the issues that the parties are calling upon you to resolve. And in post-termination claims, the issue is whether or not this claim for industrial injury is compensable. Does it qualify as an industrial injury? Now the law says that post-termination claims, unless they meet a very specific set of criteria, post-termination claims do not fly. They do not fly. They do not become accepted injuries. That's why they come to you already having been denied. A denied claim for weeks, for months, and in some cases they've been denied even for years. Okay? So in the case of a denied claim, what's the role of us as the qualified medical evaluator? It's quite interesting. If the claim comes to us on a denied basis, what's our role? What's our role? See, the claim is denied on an administrative basis because the law specifically denies post-termination claims. It says post-termination claims don't fly because they're simply a form of retaliation of the employee against the employer. Now, unless a certain set of criteria can be met, the claims are denied on an administrative basis, and they can continue to be denied forever. Stamp, period, end of discussion. So why do we get these cases? Well, sometimes the parties, and specifically the applicant attorney or the applicant, can demand a medical determination. Now, what is the purpose of the medical determination? The claim is already denied. It's already denied on an administrative basis. We could have an examinee come to us with a bona fide condition. They could have fractures, pneumothorax, concussion, myocardial infarction. On the day of our evaluation, they have bona fide conditions. But if the claim for those injuries is filed after the date of termination on an administrative basis, the claim is denied. Okay? So what's our role? Our role is to determine whether or not on the date of our evaluation a bona fide condition exists that is consistent with the examinee's description as to how such an injury could, would, or should have occurred. Okay? Our job is not to opine either for or against an industrial injury. As I said, the claim has already come to us denied. A decision has already been made administratively based on the law against an industrial injury. So let me reiterate, what's our role? Okay? Our role as the qualified medical evaluator is to determine on the date of our evaluation, does a bona fide medical diagnosable condition exist that could be consistent with the examinee's description as to how the injury occurred. And we'll talk a little bit more about how to do that in just a couple minutes. But before we do that, and before we get into the labor codes that I want to share with you today, I want to put the post-termination claim timeline in perspective. And then I want to share with you very briefly 3 cases that I have on my own desk right now that involve post-termination claims. And I won't share them with you, but I'm also aware right now of 2 additional cases from doctors that are out in the field who are also evaluating employees who have filed claims for injury after they were terminated from their employment. So this is a very common and recurring theme. You may have heard me say this before in this series, and that is the number of scenarios and the number of situations that we're called upon to evaluate is finite. And over time, as you do more and more evaluations, you're going to see themes recurring over and over and over again. It's the same recurring theme with just another face and another name. And this is one of those themes that involves the post-termination claim. So let's take a quick break right here, and I'm going to get out the whiteboard, and I'm going to put into perspective for you the timeline involved with post-termination claims. So I look forward to being back with you here in just a moment. Okay, I'm back with you now, and I have the whiteboard out here. And let's go over some of the timeline sequence of events that typically occur with these post-termination claims. I'm going to share with you 3 cases that I have on my desk as we speak. Okay? So we have a timeline here that describes the progression of time from earlier dates in time to more recent dates in time. And what I have for you first is a case that's on my desk. I'm working on it as we speak, that involves an injured worker who claims an injury in August of 2015. This is an injury to the left wrist. He claims an injury in September of 2015. This is an injury due to foreign object in the eye, and then claims an injury in October of 2015, and this is an injury to the neck, the right shoulder, and the lumbar spine. Well, the injured worker was terminated on November 15. Terminated from employment here. Let's draw that in like so. Well, on December 15, the injured worker presented for his first medical treatment related to the wrist injury and the neck, shoulder, lumbar spine injury, and he presented to a medical provider here for the very first time. And this was the first initiation of claim for industrial injury. So this claim was filed 30 days post termination here. Okay? That's one claim that I have on my desk. That's on my desk right now as we speak. Another claim that I want to share with you involves a 60-year-old female doctor who on 1/1/15 had a non-industrial lower back injury at home, doing activities of daily living around her home. Specifically, she was unloading the dryer full of clothes. She suffered a lumbar spine injury. She sought medical treatment the same day and medical treatment thereafter for the lumbar spine. This is a female doctor. Now, following this non-industrial lumbar spine injury here, the doctor never returned back to work. She never returned to work. And in through February, March, April, May, she pursued treatment for other non-industrial musculoskeletal conditions. Conditions with the upper extremities, conditions with the cervical spine, conditions with the knees related to osteoarthritis. She was receiving psychiatric treatment on a non-industrial basis due to issues related to an abusive relationship, and there was a lot going on. Well, out here in October of 2015, some 10 months after the non-industrial injury at home, she filed a claim for workers' compensation benefits. Now, she had never returned back to her work as a doctor. But out here 10 months later, she filed a claim for workers' compensation benefits. Now, at no time in here that I'm aware of was she terminated from her employment. So this does not classically qualify as a post-termination claim, but I'm going to share with you some language from Labor Code 3600, which in my opinion, qualifies this by analogy to a post-termination claim. And the language that I want to share with you has to do with what's referred to as a voluntary layoff. Labor Code 3600 also describes voluntary layoff. So it's my opinion that the doctor, having never returned to work after the non-industrial lumbar spine injury, which probably resolved right here in this early time period, after that she pursued treatment for other conditions and voluntarily decided not to go back to work. Okay? My opinion, that's also discussed under Labor Code 3600. And then finally, third case I want to share with you is on my desk right now. Involves an injured worker who worked for same company between the dates of 2005 and 2013. Let's call this December 2013. She was terminated December 2013. This is the date of termination. In 2014, I hope you can see this, 2014, she filed a claim for industrial cumulative trauma between the dates of 2005 and 2013. So we'll talk about each of these three cases and how they fit in to the language described in Labor Code 3600. All of them involve some component of the filing of the claim post-termination or post-voluntary layoff. Okay? So let me put the whiteboard away and I'll be right back with you in just a moment. Okay, so let's review a couple of labor codes, including Labor Code 3600, and put this post-termination claim into a perspective that we can deal with as qualified medical evaluators. Now, what I want to do is I want to make an analogy between Labor Code 3600, which I'll define in just a minute, and another of the labor codes that we rely on to guide us as qualified medical evaluators in our evaluation. And this has to do with Labor Code 4664 as relates to apportionment of the permanent impairment. So let me read for you section 4664B. It says, if the applicant has received a prior award of permanent disability, it shall be conclusively presumed that the prior permanent disability exists at the time of any subsequent industrial injury. This presumption is a presumption affecting the burden of proof. Now, this is a law. This is a law. The law says that at the time of an injury, if the injured worker before that had a prior award of permanent disability, then that prior award of disability exists at the time of the new injury. So if a person had a 2005 lower back injury that resulted in a 10% permanent impairment award, and they have another injury in 2016 to the lumbar spine, we presume, it's called a conclusive presumption, this is the law, we presume that at 2016, at the time of the second injury, the lumbar spine was already bad. It already had 10% impairment. It was already a bad back. The lower back was already wrecked by the time of the second injury. It's the law, and this part of the law is new. This part of the law came around in 2004 with the passage of, what was it, SB 198 or 194, or not 863, but I forget. But it came around in 2004. It says that any prior permanent disability exists. What's the relevance of that as relates to the post-termination claim? Well, simply that the law guides us as evaluators as to how to handle those cases that have a prior permanent disability. It tells us that we have to apportion that portion out of the new current permanent disability. If the new current disability is 15% and they had a prior disability of 10%, they only get 5%, which is the new permanent disability. The law tells us as evaluators how to handle it. How to handle it. Well, similarly, the law tells us how to handle post-termination claims. It's not subject to subjective opinions, feelings of the day. I really like that person. It's written in the law. Let me read this to you. This is Labor Code section 3600, section 10A through D. Okay, it says, except for psychiatric injuries. So we're talking about musculoskeletal injuries, internal injuries, cardiac injuries, respiratory injuries, everything but psych. It says, where the claim for compensation is filed after notice of termination or layoff, including voluntary layoff, and the claim is for an injury occurring prior to the time of notice of termination or the layoff, no compensation shall be paid unless the employee demonstrates by a preponderance of evidence that one or more of the following conditions apply. So the employee has to demonstrate that one or more of the following conditions apply. And it's an interesting parallel between that and Labor Code 4664 regarding apportionment. It says, this presumption is a presumption affecting the burden of proof. Upon whom does the burden of proof lie? It's a good question, huh? Many doctors feel that the burden of proof lies upon them to rebut the conclusive presumption. Many doctors will opine in their report that following the prior permanent disability, the examinee rehabilitated himself. They went to therapy, they went to the gym, they lost weight, they rehabilitated themselves, and the prior award for permanent disability disappeared. But that's not the doctor's job. The rebuttable presumption affecting the burden of proof falls on the employee or the employee's representative, which would be the applicant attorney. There's an interesting parallel there between these two laws. So it says no compensation. They get no compensation. No medical benefits, no temporary disability, nothing. They get nothing. Unless they can demonstrate one of the four situations apply. That, number one, the employer has notice of the injury prior to the notice of termination or layoff. In none of those three scenarios that I showed you on the medical record did the employee notify the employer of any kind of an industrial injury. They did not notify the employer that they had an injury. They waited until such time as they were terminated to notify the employer. Now, let me ask you, if an employee actually had an injury prior to being laid off, wouldn't they notify the employer? How would a bona fide person in this situation behave? How would you behave? How would I behave? I would notify my employer, right? Most jobs have that as their company policy, that you're to immediately notify the employer of any injury. And in none of those three cases did the employee notify the employer. Strike one, does not qualify. Number two, the employee's medical records existing prior to the notice of termination or layoff contain evidence of the injury. Okay? So if the injured worker claims that they were injured here and they were terminated here, and they file the claim post-termination, if those medical records in between the date of injury or the reported date of injury and the date of layoff show evidence of the injury, maybe they treated at their primary care physician at Kaiser or what have you, and they reported to the doctor that they injured themselves at work, and there's evidence of the injury in the medical records, then that qualifies as a compensable injury under Labor Code 3600. Absent any of those medical records, does not qualify as an industrial injury. Thus, the importance of the medical records. And you can analogize to this relating to your decisions in general with all of your claims. If there are no medical records to substantiate a claim that the examinee is making, you can analogize to Labor Code 3600 Section 10B in this case, that absent medical records or absent evidence, it says, contain evidence of the injury or evidence of the fact or evidence of the claim, you can simply use this as a basis by analogy to opine against that claim, against that symptom, against that circumstance, what have you. Now, for specific injuries, Section C says, and this is what the employee has to be able to demonstrate by preponderance of evidence, and this relates to specific injuries. The date of injury, as specified in Section 5411, which deals with specific injuries, is subsequent to the date of notice of termination or layoff, but prior to the effective date of termination or layoff. So the employer comes to the employee on September 1st, and he tells the employee that on December 1st, you're going to be laid off. September 1st is the notice. December 1st is the date of layoff. Well, if the employee injures themselves on October 1st, in other words, in between the date of notice and the date of termination, they injure themselves in between, then that qualifies as an industrial injury. That's not a post-termination claim. It's a claim that occurred post-notification, but not post-termination. Similarly, for cumulative trauma injuries, and the law here provides a very narrow window for the filing of claims for cumulative trauma. It says that the date of injury, as specified in section 5412, which is the section that gives us our rules for the date of injury for cumulative trauma injuries, is subsequent to the date of the notice of termination or layoff. The date of injury is after the date of notice of termination or layoff. And I said that this was a narrow window, so let's analyze this. Again, the employer comes to the employee on September 1st and tells them that so here's September 1st, and tells them on December 1st they're going to be laid off. Well, they can report a cumulative trauma injury with a date of injury in between the date of notice and the date of layoff. But you see the narrow time window for the cumulative trauma injury? In other words, the notification generally is delivered somewhat proximate to the date of termination, and so that creates a very narrow window for cumulative trauma claims. So these are some of the things that you're going to look for. You're going to look for employer notification of some type of an injury. You're going to look for medical records in the primary care physician's office or in the employee's personal medical record for evidence of the injury. But absent that, these claims will be denied on an administrative basis. It's the law. It's the law. So that brings us to an important point. If these claims are denied on an administrative basis according to the law, and we're getting these cases, which we are, we're getting these cases under Labor Code 4060, the compensability labor code. What's our role? What's our role? Well, I want to talk to you about our role, and I want to give you just a couple of things to consider as you formulate your opinions and conclusions on these cases. Our role as the qualified medical evaluator is to determine whether or not a bona fide condition exists. Now, it's interesting. One of the cases that I shared with you on the whiteboard, the cumulative trauma claim for cumulative trauma between 2005 and 2013, 2005 to 2013, the qualified medical evaluator didn't do his evaluation until 2016. 3 years post-termination. So his job is to determine, does a condition exist 3 years now after the date of termination? And is it possible that that condition, if it exists, if it actually exists, is it possible that that condition could be somehow related to the workplace activities, the way that the examinee described the injury to occur and the way the examinee describes the workplace activities to have caused such an injury? In other words, the medical determination that we're required to make is there a condition, and is it possible that that condition could be related to the industrial activities? So let me give you just a couple of things to consider. One is what's referred to as the temporal relationship. Temporal relationship. And temporal comes from like temper or like temporary, means related to time. So if you're examining an examinee a month, 2 months, 3 months, 6 months, 12 months, and in the case I just described 3 years, after the date that the injury is supposed to have occurred, it becomes harder and harder and harder to relate any symptoms to any injury that occurred so long ago. There's what we refer to as a loss of temporal relationship. Another thing to consider is the examinee's motivation. The examinee's motivation. Now, in the case where I drew on the whiteboard where the doctor had a non-industrial injury at home on 1115, and did not report or did not make a claim for industrial injury until 10/2015, the question becomes, where was she on February 2015? Where was the claim in March 2015? Why did she not file it in April, in May, in June, in July, in September? Where was the examinee all this time? And why finally in October of 2015 did the examinee make a claim? Similarly, with regards to the cumulative trauma claim between 2005 and 2013, she filed that claim in 2016. Where was she in 2006? Where was she in 2007? Where was she in 2008, 2009, 2010? In other words, thousands of days are going by here where she's supposedly suffering cumulative trauma, and yet there's no claim. There's no claim until such time as she's terminated from her employment. And it raises the question of the examinee's sincerity, the examinee's motivation, and the examinee's motives. In fact, it raises it to such a level that the law has been passed. It's called Labor Code 3600, which administratively denies these claims. So I urge you as qualified medical evaluators to consider and explore the examinee's motives or motivations behind filing such a claim. So we can look at these cases from several perspectives. Ultimately, you are required to make a determination as to, number one, is there a medical condition, bona fide medical condition that's diagnosable, it's active on the date of your evaluation, and if so, is it possible that that condition could somehow be related to the industrial exposure the way that the examinee described it? Now, if you opine for an industrial injury, your rationale better be very, very good, because you're going to be attempting to rebut the law. You're attempting to rebut the law. It's like trying to opine that a prior permanent disability didn't exist when the law says conclusively it's presumed to exist. So you'll be attempting to go against established law. So your rationale and your reasoning had better be good. Had better be good. If you're opining against an industrial injury, again, your reasoning has to be very good, and you should elaborate on the reasons why in your opinion, this does not qualify as an industrial injury. And I gave you a couple of reasons to consider. One is the loss of temporal relationship. Another one has to do with the examinee motive or the examinee motivation for filing a claim. Another one has to do with what we refer to as the law of reversibility. The law of reversibility says, and this especially applies to cumulative trauma claims, that if we remove an examinee from an injurious environment and time goes on, in other words, they have a cumulative trauma claim up until a point in time, they're now terminated, they then file a claim for industrial injury, but they're removed from the injurious environment here for a period of time, we expect the law of reversibility to reverse their symptoms. In other words, if you're involved with repetitive motions and you remove the repetitive motions, your symptoms in time, we expect, are going to resolve. The law of reversibility should kick in. So if you see the examinee for an evaluation months after the termination, months and years after the determination, we would have expected that any symptoms related to industrial, cumulative, or even specific injury would mostly have resolved simply by reversibility and natural history. And if the symptoms are persisting at some time far removed from the date of injury, it's quite likely that there's other factors involved with producing those symptoms. And in the employee that I was referring to related to the 2005 to 2013 industrial cumulative trauma, the other factors did indeed involve, coincidentally, prior permanent disabilities to the hands, to the neck, and to the lumbar spine. She actually had 2 prior workers' compensation injuries, both of which resulted in large levels, high levels of permanent disability. One of them resulted in a permanent disability award for 58%. So there were other factors perpetuating the symptoms. So elaborate on your reasonings as to why for an industrial injury or why against an industrial injury. And if you opine against an industrial injury, you can also cite your directive under Labor Code 3600, but I recommend that you cite that as your final reason, not as one of your initial reasons. I recommend that you cite first medical reasons as to why you opine against an industrial injury, and support your medical reasons with the legal administrative reason. But don't begin with the legal administrative reason, because we're not lawyers, we're not claims administrators. Our job is to provide medical conclusions. So begin with medical conclusions and support it with the legal conclusion versus the other way around. Okay? In most cases, you will be opining against industrial injury in these post-termination claims, because it's my opinion that it's going to become very difficult for you to find proper support to oppose, number one, the law, and then number two, that makes sense even medically, based upon lack of reversibility, loss of temporal relationship, and suspicious motivation by the examinee. These claims are going to be very difficult to support. So doctors, I hope this helps you. This is a large bulk of the cases that we get involve, number one, denied claims under Labor Code 4060. And then of the denied claims that we get, there's a limited number of reasons that the claims would be denied. Why would they be denied? They're denied on legal and administrative reasons. And one of those legal and administrative reasons is because the claimant, the employee, simply filed the claim after they were fired, the post-termination claim. So the claims administrator immediately puts a stamp of denial on those claims. The employee gets disgruntled and wants to retaliate, so they get an attorney, and the applicant attorney declares a dispute and demands a medical determination. In the case of this medical determination, what's the determination? As we said, it's to determine, does a bona fide condition exist? Okay? Likely that a bona fide condition is not going to exist at some great time after the reported date of injury. The medical condition will probably not even exist unless the examinee fakes it completely. So it's likely that the condition won't exist. But if a bona fide condition exists, is it possible that that condition could be even 1% due to the industrial exposure the way the examinee described it? And in most cases, the answer to that is simply going to be no, unless you've got great, great, great support for a yes determination. So doctors, I hope this helps you. This gives you some things to look at, and I hope it helps you see the big picture of your claim. And I want to encourage you to try and define your claims in advance so that you know going into the evaluation what is your specific role for that evaluation and how can you help resolve and move this case forward. So for today, I want to thank you for being with me on today's video. Look forward to being with you next week, where we conclude and summarize the QME Top 10 series. And it's been a fascinating series, and I'm going to bring it to a resounding close and a dramatic close in our very next session. So I look forward to being with you then. That will be a don't miss session. So please don't miss that session. For now, this is Dr. Perry Carpenter. Hope you enjoyed today's presentation, and for now I'm wishing you best of success in your career as a qualified medical evaluator.